I would say that I don't believe the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all what this is legitimately 4 and 5 with another one pending in Wayne County and he's still using, you're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, like Defender Ben Denwick on behalf of Mr. Barnhart, who stands to my right, would you state your name for the record, please?
Philip Barnhart.
What are we doing?
Your Honor, Mr. Barnhart is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
Report in receipt of the bond violation report from Community Corrections.
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor. And I understand that the defendant was released from jail on September the 2nd, went to Community Corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and Suboxone. I understand also that this was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed, therefore it may not be a bond violation. However, I did double check ex-jail and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. So it's possible that certainly the THC could have been from before. The cocaine I'm less certain of, with extremely heavy use, maybe 96 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument, but.
Can I have just a second, Your Honor?
Sure.
So, yeah, I just think there's possibilities that he's not used after being arrested. And those.
What?
I mean, cocaine could stay in his system for up to a week if there's heavy use. So the failure.
Let's say, well, I don't know, a week, but let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, I have 2 in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
I think I'm fine.
I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
But here's again my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 23. He's got a pending Wayne County one. He's got prior ones and he's still using. So I don't know that he should be out because at some point luck's going to run out. He's going to get behind the wheel and he's going to take somebody out.
I don't have a vehicle.
Your Honor, I don't believe he's driving. The test certainly indicates use. Look, drunk driving is absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. That would be a bond violation at this point because he has been on bond since, I think that would be the 29th, 28th or 29th. So if he fails the test at this point, that would conclusively prove use while on bond. And I think absolutely the court at that point would have undeniable jurisdiction to revoke his bond. I would say that I don't have the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all, this is legitimately 4 and 5, with another one pending in Wayne County, and he's still using? You're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, I wouldn't absolutely not even argue that, no question. I think him failing those tests, and we don't have a pattern or anything like that. You know, we don't know if this is a one-time slip up. We don't know if he's used while he was on bond. I think the court could allow him to test today, and that would solve the problem.
May I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his BAC was incredibly high. And I'm going to double check that before I get that search to the court. But if I recall correctly, I think in both cases, his blood alcohol content was above a 0.3.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern is. People would request that the court find that the bond is an abuse of discretion and set a higher bond and remand.
I just don't think the circumstances have changed since the bond was set, because and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate, at least conclusive evidence. It's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record, and he's out on basically a PR, I think is an abuse of discretion. Now, if you want to argue that with me, certainly I will hear you.
Okay. I think it would not be abuse of discretion because of the length of time that has passed. So, we're already into August 2025. The positive test, we can't really deny it, but what we can say is he's not driving far. So the extreme danger to the community that comes with intoxicated driving is not present. Obviously, there's some danger to the community in hard drug use, but I believe it's less. I believe it can be managed with restrictions such as continued testing. If he fails again, he's obviously used while on bond. The court could do that. I think the court could order increased testing. You could put him on 3 times a week. I think he was on 1 time a week. I mean, the court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set for?
I'm sorry?
What did you wish these set for? Preliminary examination?
No, he's going to waive.
He's waiving. All right. So at this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000 cash or surety. So you're waiving your right to preliminary examination in these cases?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you will not have that hearing on either one of these matters, and that this will proceed to circuit court for further resolution.
Sir.
People also waive their right.
We waive, Your Honor. I do believe he previously posted $25,000.
Oh, are on both of these?
I think that's what my notes reflect, is that that's what it was set at.
I mean, I thought they were PRs.
Sign the
It might
form to
have been
waive after this.
PRs, $25,000 PRs, but I
There, I have on each of these that they're PR.
oh, I apologize, Your Honor, my mistake. Thank you.
So people do waive.
We do.
Preliminary examination haven't been waived. Defendants bound over to circuit court on a single count in each case.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pretrial. Custody pretrial date.
September 24th at 1:30 with Judge Conlon.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters. The bond as indicated is set in each case. It will be changed from a personal recognizance to a $25,000 cash or surety. Defendant is remanded. Yes, you may. What was that date again?
24th, Your Honor.
2022 CR 7737A, State of Texas versus Jennifer Tagle. Could you please approach and could parties announce for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
Robert Gaona for the defendant, Jennifer Tagle.
And are you Ms. Tagle? Why were you late for court today?
I was running late on the bus.
All right, you got to take an earlier bus. I used to take the bus. I would end up at court for work at like 7 a.m. It's dark at that time. All right, counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, I have, Judge.
Court will find that the state is in compliance with discovery. Ms. Tagle, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
This one.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
This one.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on count 1 and waiving count 2.
Any objection?
No objection, Your Honor.
Mr. Tagle, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on count 1, which is credit debit card abuse? That's as a state jail felony. The ranges of punishment are anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You're going to have to speak up. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Tagle, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 1 year in the state jail facility. It says here there is no application for deferred adjudication.
It's an application for regular probation, Judge.
Okay. There's no application for deferred adjudication. The state recommends community supervision. There's to be restitution to Austin Galan, Galan, if any. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 3 years. There be 120 hours of community service restitution, no contact with Austin Galan and cats 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, no contest. State, any evidence?
State offer State Exhibit 1 in all attachments.
No
Any objection?
objections, Your Honor.
Ms. Taggle, I'm showing you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept any evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, it asks that you follow her plea bargain agreement with the state.
All right. And you do understand your sister was just before me blaming this entire thing on you. You understand that?
Mhm.
Your Honor, I think it was her co-defendant, Sarah Laura.
Yes, saying that she was her twin sister and it was her twin sister.
I actually think she actually does have a twin sister.
I do have.
No. That's what I'm saying. The person who came in
She
said
didn't?
it was the twin sister. Yes. And her name, I believe, is Sarah Laura. Yes. All right. So you can unfold your hands. Why are you taking things that don't belong to you?
Technically, I don't know. Wasn't thinking at the moment of this.
What do you mean you're not thinking at the moment? It takes thought to take somebody's stuff and then go to Walmart, Malone Grocery, the Family Dollar, and I don't know what you're buying for $175.88 from Family Dollar when I think everything's supposed to be $1, a little bit over $1. And then there's more Walmart trips. There's Shell gas station. There's an Uber. There's public storage. So how would you like if somebody were to take something that belongs to you and go on a spending spree? Do you have a job?
Right now, yes, I do.
What do you do?
Transportation, the state
What?
transportation.
What does that mean?
Medicaid transportation,
She
Okay.
drives a Medicaid van?
Mhm.
Is that what it?
No, she's not going to be, you're not going to be driving a Medicaid van, because driving a Medicaid van suggests to me that you're driving people. Am I right about that?
Mhm.
That's either yes or no.
Yes, ma'am.
So that means that you're driving vulnerable people who may have credit cards and may have things that you can have access to. So I'm not allowing that. You understand? So you're going to have to get another job.
Yes, ma'am.
I don't allow people on probation out of this court to be at home healthcare providers, to work with minors, to be in any type of occupation where they're around vulnerable people. So, I mean, you can get a job in construction, you can do that, but you will not be driving a Medicare van. So this is what the court will, do you have any children?
1,
Age?
7.
Okay. Live with you?
No.
Why not?
Those are my mom and dad.
So that means that there's somebody else taking care of your child. Are you paying child support?
Yes, I am.
How much?
120 every 2 weeks.
Is Child Protective Services involved?
No, ma'am. The
That-
case is closed.
All right. So that tells me that you didn't do what you needed to do. Otherwise, you'd have your child. There's going to be a $1,000 fine probated. As previously stated, the court is finding you guilty. There's to be restitution and no contact with Austin Galan. Proof of employment within 30 days. Probation. She is not to be driving a Medicaid van or working with any vulnerable people. And there's to be no employment as a home healthcare provider or with minors. And you can give them you're going to give your employer your 2-week notice, so they won't be left in the lurch. So you're going to give them a 2-week notice. And after those 2 weeks are up, you're not allowed to work there anymore.
Yes,
1 year in the state jail facility, suspended and probated for 3 years, 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. You are going to complete parenting classes. I guess you didn't complete them for CBS, but you'll be completing them here. So there's to be parenting classes. Once she's done that, the remaining community service hours will be waived. There's going to be CATs 1 and 2. There's to be regular reporting by Zoom or in person. There's to be field visits 1 time per month. There's to be no unsupervised contact with minors. And there's to be regular UAs. And if you're drug tested today, what are the results going to be?
30,
For what?
40.
All right. And so you are driving and you smoke. That's a problem.
I already gave her my 2 weeks notice.
Okay, great. So you're just hopping from job to job. All right. I'm going to want her to do the UA hotline. And she's to be tested at least every 2 weeks until she's clean. And then there will be sober meetings. Probation, is there anything else she needs? Is there anything else you need from the court?
Mm.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Probation will go over conditions.
Thank you, Judge.
You're welcome. The court is calling 2022 CR 3998, State of Texas versus Jacqueline Wells. Could I have parties announced for the record for the state? For the defense?
Alberto Rodriguez.
Well, you come on. Come this way then.
All right, are you Jacqueline Wells? All right, you need to speak up so that I can hear. Showing you what's entitled Motion to Enter Adjudication of Guilty and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Speak up.
Yes, ma'am.
All right, why are you mumbling?
That was my mouth hurts. I'm sorry.
I'm sorry, what?
My mouth hurts.
Okay. So, did you review this document with your attorney and did you understand it? Are you the same Jacqueline Wells who was placed on deferred adjudication in 2022 CR 3998 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram, on July 7, 2022 for a period of 2 years? Is that you?
Yes, ma'am.
State?
Yes, Judge, violated condition number 1 on or about the 29th day of August, 2022 in Bexar County, Texas. The defendant, Jacqueline N. Wells, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
We'll waive all other violations, Judge.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Defense, do you have any objection to the state's waiver of violation of condition number 4?
No, Your Honor.
All right. Is there an agreement?
Yes, Judge. We're asking that you deny the motion and alter amend her conditions for status. In addition, we'll be taking into consideration NITMAC number 676841.
Is that the agreement?
It is, Your Honor.
All right, Ms. Wells, can you raise your right hand for me, please? Do you solemnly swear or affirm that testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Jacqueline Wells.
All right, so why are they recommending that you go to SATF? What is your issue?
You just suggested that.
No, here's the thing, SATF is for people who have drug problems. So why would they recommend that you go to SATF?
For drugs. That's why I'm on probation for drugs.
Well, here's the question. You're looking quizzical at me, which is fine. So I'm going to be more direct with my question. Do you have a drug problem? That's either yes or no.
Okay, yes.
What is your drug of choice?
Yeah.
How long have you been using that?
For years.
For how long?
For years.
What does that mean? How many
I
years?
don't know, since I was like 15.
All right. So why did you start?
I just got introduced to it and then I don't know why I started.
Okay. Do you have any children?
Yes,
What are their ages?
14 and 9
Where are they?
with them. And then,
Have your parental rights been terminated? Did you ever have a child protective services case?
I did, but it got closed.
All right, which probably means they either closed it for one or two things. Either they made the father of the children managing conservator, or either they terminated your rights, or either they just gave you possessory. I don't know because I wasn't there. I'm not the one who took this plea. So I would send you to drug court, but drug court is full. That's probably where you need to be. But that's full. So I'm going to deny the motion. Probation,
Yes, John.
even though drug court is full, can you see if they would interview her? You're still going to SATA, but once you get out of SATA, maybe they'll be able to accept you at that point in time. So I'm going to deny the motion, alternate main conditions to include SATA. I'm going to want parenting classes, the UA hotline upon release, there's 180 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 hours will be waived. The remaining hours will be waived once you complete parenting classes. If you were released, where would you be living?
With my friend.
Who is this friend?
He's just a friend that has, I don't know, he's
All right, so sometimes people use the word friend different than I use it. Is this your boyfriend?
no, but he's a good friend. Just,
How long have you known him?
for 4 years.
And so he's known you doing your addiction? All right, how old is he?
He is 29.
All right. You're not going to be allowed to live with him. And let me just tell you why. I'm a firm believer that if you hang out at the barber shop long enough, you're going to end up getting a haircut. So I think that he's probably using as well. And we can't have two people who are addicted to drugs coming together, because it never fails that when one is doing well, the other one is not. And then it sort of leads you down the rabbit hole to using drugs. So you're going to have to get a place by yourself. And I'm going to recommend for you, I can't order it, but you should not be in any relationship until you work on you, so that at some point in time, you can be involved in your children's lives. Okay. So, and there's going to be no